December 13th, 2021.
I ask counsel to please enter their appearances. Thank you, counsel. Ms. Davy?
Thank you, Your Honor. I would like to reserve 3 minutes for rebuttal, if I may. Your Honor, this case comes before the court today on original jurisdiction from a direct appeal of Mr. Roberts' convictions for first-degree felony murder, second-degree murder, and attempted second-degree murder. The charges stemmed from an incident at the corner of 11th and Massachusetts Street in Lawrence, Kansas. The state alleged that Mr. Roberts intentionally killed Colwyn Henderson, and in the course of committing that second-degree murder, killed Leah Brown and Tremel Dean and shot Taze Rayton. Mr. Roberts' appeal lies primarily in the sufficiency of the evidence to support his convictions. More specifically, the state did not present evidence sufficient to prove beyond a reasonable doubt that Mr. Roberts intended to kill Mr. Henderson, nor any causal evidence that Mr. Roberts, intentionally or not, actually killed any of the victims. For purposes of the argument today, I want to begin with the insufficiency of the evidence and move to the jury instructions later. In this case, the state could not forensically tie any specific bullet or any specific gun or caliber of gun to any of the victims. And this is important because in this case, there was evidence of at least 2 shooters on the scene that night. The undisputed evidence was that Mr. Roberts fired his 9mm Glock 26, and there were 9mm shell casings recovered that were consistent with his firearm. That's undisputed. However, there were also 6 .40 caliber shell casings that were collected at the scene, which are evidence of a second shooter, and there was additional testimony about an additional shooter, Ahmed Rayton. The ballistics expert that testified at trial testified that she was not able to establish that any of the bullets or bullet fragments that were recovered from any of the victims could be tied specifically to Mr. Roberts' 9mm firearm. And likewise, the medical examiner testified that he could not state conclusively that any of the bullet fragments that were recovered could be tied to any of the victims' injuries, nor could he testify what caliber firearm caused any of the victims' injuries. The state presented no evidence that the same caliber bullet killed all 3 victims. The state presented no evidence whatsoever that affirmatively linked Mr. Roberts' firearm to any of the victims that night, nor any evidence excluding the firearm or tending to exclude the firearm of Mr. Rayton from causing any of the fatal injuries. So on that issue alone, Your Honors, we would submit that there's insufficient evidence to establish beyond a reasonable doubt that Mr. Roberts killed any of the victims in this case. Your Honor, I don't think that the jury could reasonably infer from the evidence in this case that it was exclusively Mr. Roberts' firearm that caused the injuries in this case. If the evidence had been that there was only one shooter, then yes, I think the jury could have inferred a firearm was discharged, somebody was shot, there's a reasonable connection between the two. But in this case, because there was a second shooter and because everything happened in such a short period of time, I don't think that the jury could reasonably infer that connection. And it was part of the state's burden to provide some information, either affirmatively linking Mr. Roberts' firearm to the injuries and the fatal injuries, or to give some evidence which would tend to exclude Mr. Rayton's firearm, and the state did neither in this case. And so, no, I don't think that there's a reasonable inference there. However, there's also an issue with the sufficiency of the evidence as it relates to the element of intent on the second-degree murder charges. The theory advanced by the state at trial was that Mr. Roberts' friend, DeCory Brown, had been involved in an altercation earlier that evening, and Mr. Roberts came to Lawrence for the specific purpose of settling a score. In fact, that was a recurring theme in the state's closing argument, that Mr. Roberts was trying to settle a score. However, the state presented no evidence that Mr. Roberts had actual or any kind of constructive notice of Mr. Brown's earlier altercation, or that Mr. Brown had any knowledge of, or Mr. Roberts had any knowledge of who was involved in that earlier altercation, or specifically that Colwyn Henderson had been involved. And in fact, the evidence that came out at trial was that Colwyn Henderson had not been involved in that earlier altercation. And so that theory was not borne out by the evidence to prove an intent to kill Colwyn Henderson. There was an alternate theory advanced at trial that there was some history of bad blood between Mr. Roberts and Mr. Henderson. However, the state presented no evidence that Mr. Roberts, when he came to Lawrence, knew that Mr. Henderson would be in Lawrence, presented no evidence that Mr. Roberts knew that he would find Mr. Henderson on Massachusetts Street that evening, and no evidence that Mr. Roberts came to Lawrence with the intent to kill Mr. Henderson. The evidence that was presented at trial was consistently that Mr. Roberts had always intended to come to Lawrence that evening to attend a concert, that he always carried a firearm with him for protection, and that there was nothing different or unusual about that behavior that evening. There was some evidence of a previous, I suppose, interaction that evening where the groups had passed each other. I think I would note two things there, Your Honor. One, that previous interaction between the groups would seem to indicate that there wasn't an intent to kill Mr. Henderson, because there was no incitement by Mr. Roberts of an altercation at that point.
Roberts knew Henderson was going to be. At that point, he did.
At that point, he did, Your Honor. That is true. And the evidence was that there was no incitement of an altercation at that point. The only evidence that the state presented to try to create an inference of intent at that point was that Mr. Roberts allegedly said, "What's poppin'?" But there was no evidence of what that was intended to mean. There was no evidence that that was intended to be an incitement towards Mr. Henderson or anybody else in the group. In fact, the state's star witness, Robert Wheeler, testified that that comment was made generally to the group and not to anyone in particular.
But didn't he also say that Roberts was waving a gun when he said, "What's poppin'"?
Mr. Wheeler testified that Mr. Roberts had his gun in his hand, and he testified that it was down. He had his arm down lengthwise.
By his hip.
Yes. So, yes, he did testify to that. That was contested evidence, which of course the court can't reweigh. But there was no incitement of Mr. Roberts at that point to attempt to use his firearm. There was no pointing it at anyone or any other threat from Mr. Roberts. And if his I would acknowledge, Your Honor, that there was disputed evidence. I would not acknowledge that there was sufficient evidence at trial for a reasonable jury to find beyond a reasonable doubt that there was intent. Intent can be inferred from the established circumstances of a case, provided that the inferences are reasonable. And I would submit, Your Honor, that the inferences in this case were not reasonable. There was not any evidence that Mr. Roberts made any changes to his behavior, made any overt attempts which would indicate that he had an intent to harm or to kill Mr. Henderson. In fact, the state's witness, Mr. Wheeler, the only witness who testified who was present from the very beginning of the altercation through the very end, testified that when Mr. Roberts discharged his firearm, he was running away and firing recklessly. Those were his words. There was no testimony that Mr. Roberts was aiming directly at Mr. Henderson. Even with Ms. Huggis's testimony, Mr. Roberts' cousin, her testimony was that he stopped firing when he saw Mr. Henderson fall. That is not the same as saying that he admitted that he intended to shoot Mr. Henderson. Well, there was also a self-defense asserted in this case, and so I think that's also consistent with the assertion of self-defense, that once his threat was neutralized, he put his gun away. He didn't feel like there was a threat that he needed to respond to at that point. So I don't think that the evidence was reasonable to infer beyond a reasonable doubt that there was intent in this case. There was video at trial. It is from a distance, and it is hard to see the specifics of who is where and the sequence of events. There is video, but it's very hard to determine anything conclusive from it. Your Honor, I see I'm running out of time, so I want to touch just briefly on the jury instruction issue. The jury instruction issue really comes back to the sufficiency of the evidence problem. It is our position that instruction 16 and 17, which regarded felony murder, were not supported by the evidence in the case. The court has an obligation to act as a gatekeeper and to only instruct the jury on those charges that are supported by the evidence at trial. Your Honor, I see I'm out of time. May I have leave to respond to the question? Right. Your Honor, I think I would respond in two ways. One, the instruction was not legally or factually appropriate because it wasn't supported by the evidence that came in at trial. And so the court failed in its obligation to act as a gatekeeper and only instruct on the charges that could be supported by the evidence. Correct.
That is totally dependent.
So the second point, Your Honor, is I guess to clarify, we would say that the court should not have instructed on those charges at all because they were not supported. But if the court was inclined to instruct, then the court has an obligation to ensure that the instruction is both legally and factually accurate. And in this case, I would argue that it was not either. The instructions as they were given to the jury indicated that in order to convict on the felony murder charge, the jury must find that, Leah Brown and Tremel Dean were killed while defendant was committing a second-degree murder. And that it's not true to say that that is the only way that he could have been convicted of second-degree murder. The court instructed on the second-degree murder charges on lesser included offenses, some of which the voluntary manslaughter charges also could have supported felony murder. So it was not a legally accurate instruction to say that in order to convict him of felony murder, they must find that these folks died in the course of him committing a second-degree murder.
You even have to have the first instruction. Couldn't you just instruct on felony
You could, Your Honor. Kansas law would support that. I mean, Kansas law, I think, does indicate that you don't have to have a conviction or even prosecution for the predicate charge, and so. I would agree that under Kansas law, it's legally appropriate, but it is still confusing and misleading to the jury, because the jury doesn't have any instruction or doesn't have any basis in knowledge that that predicate charge doesn't have to result in a conviction in order to convict of felony murder. The instructions that the jury is given indicates that in order to convict of felony murder, they must find that these deaths occurred in the course of the commission of a second-degree murder. And to a jury, that creates, I mean, that is a misleading statement of the law. That is not the only way to convict him. And it creates a position where if the jury wants to seek justice for these victims, which was an emotional appeal, a central part of the state's case, if they want to seek justice for these victims, then they necessarily have to work backwards and make the second-degree conviction. And that's what we're alleging is an error, that the jury was put in the position.
What's the proper instruction? That in the felony murder instruction, it should not only include second-degree murder, but also the lesser includeds that were included for second-degree?
That would be one option. I mean, I think, Your Honor, our position is
And
that.
it seems like a cumbersome instruction, but that's would be one of the options, is just to include the second degree plus every lesser that they are instructed on that is an inherently dangerous felony that would satisfy felony murder.
Your Honor, I think our position would be that the instruction shouldn't have been given at all.
No, I understand that, but if it is.
But yes, then I think the court could have instructed on, the element of felony murder. The second element is that this killing happened in the commission of an inherently dangerous felony. Here's the definition of an inherently dangerous felony. Here are the other inherently dangerous felonies that would support that conviction that have been instructed on the second-degree murder charges, and give the jury some additional information about what other inherently dangerous felonies might have supported the conviction.
So here, if the jury had convicted of the lesser on second-degree murder of voluntary manslaughter, that would not have supported the felony murder, correct?
Correct.
after the court read the instructions to the jury, which defense counsel said, do you want a homicide? And defense counsel said, no, that's not. You have to prove, and
I would not, Your Honor. I think that is a different issue altogether. The homicidal act instruction was effectively a transferred intent instruction, and that was included in instruction 18, which was the attempted second-degree murder of Taze Rayton instruction. There is no transferred intent for a felony murder because the intent comes from the felonious intent of the underlying felony. And so the defense's response to the court's inquiry there was that wouldn't be an appropriate instruction for that charge. The state agreed, and there was no further discussion about that. So that, I don't think, is invited error because, one, that's not the error that we're complaining of at this point, and two, I think that was an accurate statement of the law.
Questions?
Sure.
Mr. Obermeyer?
Thank you. Good morning. May it please the court. The state appears by Stephen Obermeyer. It's nice to be in a venue where I don't feel like I'm one of the Hollywood squares watching the court over a Zoom argument. I'll address the issues in the order they were written, jury instruction, and then sufficiency. As it relates to the jury instruction, I think this morning is the first time I've heard the argument that there wasn't sufficient evidence to support a felony murder instruction, and that's why the court erred. My understanding of the argument was the court should have also instructed on a killing during the commission of a voluntary manslaughter, as the state's brief indicates that there are no lessers of felony murder. In fact, defense counsel argued that in urging against such an instruction by saying there was no theory that it was a bullet aimed for somebody else. There is no lesser included, so the state's theory is that Mr. Roberts was never intending to strike her, Leah. He was only intending to strike Colwyn Henderson, and they have to prove that for second-degree murder. That's at page 2,436 of the record. And defense. That was Judge Picorni's question. We don't have the homicidal act. I've read it as that. It's not that second degree is the state's theory, and there's no lessers, and I think they should be bound by that, and especially when they go on and argue in closing that if you do not find the elements of second degree murder are met beyond a reasonable doubt as to each one, you should find him not guilty. To now come up here and say, well, should have instructed on voluntary manslaughter as an option or an alternative means, which brings us to the clearly erroneous argument, which is, would the giving of the proposed instruction have made a difference in the verdict? If the jury had found him guilty of felony murder during the course of a voluntary manslaughter, that's not a difference in the verdict. It's still a felony murder conviction. No, Justice Standridge. The state's argument is that voluntary manslaughter is not a lesser degree of felony murder under KSA 215402A2, and also it was not charged as an alternative means of committing felony murder. The state as a lesser of second degree murder, because KSA 223414 says when there's some evidence of a lesser crime, the court shall give that. And so that's why you have the lessers of second degree murder given. But when it comes to lessers of felony murder, the statute was amended in about 2013 to say there are no lessers of felony murder.
This isn't offered as a lesser to felony murder. It's offered as a lesser to second degree murder consistent with the instruction for second degree murder. In other words, if they would have found under the state's or the defendant's theory that would have been guilty of voluntary manslaughter, and that would suffice for the underlying felony, it would be guilty of felony murder. There's the only way to find Mr. Roberts guilty of voluntary manslaughter is under the second degree murder lesser included instruction. I think that was instruction 3, not under the felony murder. There's no lesser instruction on the felony murder charges, is there? So I think the argument is that should have been, as the underlying felony, it should have been second degree murder or voluntary manslaughter. That's the theory, I think, or that's what they're offering.
Yes.
Not that there's not a lesser to felony murder, right?
Right, correct. As I see the argument as well, second degree murder has a lesser, so they should have been instructed as voluntary as another inherently dangerous felony, which I think the briefing says there's no lessers of felony murder, and the state didn't charge felony murder either committed during the commission of either second degree murder or voluntary manslaughter. And if that had happened, we'd be here arguing about whether the defendant was prejudiced by, closing in jury instructions, having this new theory of the case that was not charged. In State versus Trottloff is a good case that discusses that. as I read, and also the jury was instructed, you shall consider each count separately. And I did brief that you could have an
Let me just ask
inconsistent
you,
verdict.
I think it's an interesting question that Mr. Roberts' counsel raises, is that had the jury found Mr. Roberts guilty of voluntary manslaughter, there was no means to hold him accountable under the felony murder instruction. Is that right?
I think you'd be into the inconsistent verdict area of the law where I haven't briefed it, but I think you could still argue that, Justice Rosen. And I think I cited a case where the defendant was acquitted of the underlying felony, but found guilty of felony murder. And the court said that was permissible. I think that's State versus Poole, cited at page 25 in the state's brief. But we don't even have to get there because it would not have made a difference in the outcome of the case. The jury is presumed to have followed the jury instructions, and they weren't compelled to find the defendant guilty of second-degree murder, only to find the defendant guilty of felony murder. The jury swore they could follow the rules. They're presumed to have followed the instructions. There was a juror who went to law school with defense counsel on the jury. And surely they would have said something if it was a rogue jury, runaway jury here. We're just disregarding the instructions. We don't have any of that. I think we presume that the jury followed the instructions. And it did not result in a forced conviction of second-degree murder. As it relates to the first issue, I think, Justice Standridge, your questions asked were relevant, that you're not reweighing the facts. There might be evidence from the defendant that, yes, I wanted to drive to Lawrence to see a concert. Of course, he has a blocker car in front or behind him, so it can't be apprehended. And they get their way after the concert's over, and the jury's not required to believe the defendant's version. And the defendant even said to the detectives, said something about his credibility that you may not believe me. State versus Brunson says the jury's not required to believe the defendant's version of the offense. So they drive from Topeka to Lawrence on a busy night. A lot of people on Mass Street. Night at the Fog is a little ways away. And the defendant jumps out from this Japanese garden area and accosts Robert Wheeler and Colwyn Henderson and says, "What's poppin'?" I don't think he's talking about the kettle corn display if there's one around there. Why would you say what's poppin' to somebody when you have a Glock with 27 bullets on it? And to his detriment, Colwyn Henderson says, "What's up?" Like he's going to take his jacket off and fight. And Robert Wheeler says, let's not do this. He's got a gun. Let's get out of here. And they walk away. And then it turns out that who ends up getting killed later? Colwyn Henderson. And the defendant did say, I shot Colwyn and put my gun away when I was done. And I think he even testified, we had no more business in Lawrence. So we left Lawrence, by the way, with the blocker car and giving the police officer who stops him on 6th Street in West Lawrence a false reason for why they were there. The defendant told the police, we were never in downtown Lawrence. We were visiting my aunt, whose birthday was today. Now, is the jury required to believe that? No. The aunt testified they didn't come see me. I was working at the hospital that night. There had been I think, an order in limine on the gang evidence. So that's why there's not a whole lot of evidence as far as the bad blood or that somebody had killed somebody's relative before that they didn't get along. But I think there was sufficient evidence of an intent. This is not a premeditation intent to kill case. And I discussed the Stanley case in the brief. That the state had to show the defendant's actions needed to be intentional, but without cognitive reflection, without deliberation or without pondering, an internal snap decision that can be instantaneous and even unconscious. And we almost get into a fight minutes earlier with Colwyn Henderson, who starts to take off his jacket and says, "What's up?" after the "what's poppin'" question, combined with the flight from Lawrence, the fabrication of evidence with the false story as to what we're doing in Lawrence, having heard about 35 witnesses over about 10 days, I think a rational fact finder could fairly conclude that the defendant was guilty of intentional second-degree murder. The other bullets, and the other thing with the argument that, well, the state has to match up bullet fragments to the bullet now to be sufficient evidence to find somebody guilty, that's a high hurdle, especially in light of the defendant claiming, well, I shot in self-defense. I mean, he's admitted shooting, so we have to still match the bullet fragments. I think that's all the arguments I have on those two issues, unless the court has any questions.
Thank you,
Thank
Mr.
you.
Obermeyer.
I'd ask you to affirm his convictions. Thank you.
Reserve 3 minutes.
Thank you, Your Honor. Briefly, on the issue of harmless error, the question for the court in harmless error is not, would there still have been a felony murder conviction? There could have been. We don't know because the instruction wasn't given that would have allowed that possibility. But even if there had still been a conviction, it would have been for it could have been for a different charge. And the law is not that if the sentence could potentially be the same, then it's no harm, no foul. Anytime you have an inaccurate or a factually unsupported conviction, that by its very nature is harmful.
I was going to go back to the question. So is it your that was
I think the court can consider both. I mean,
I just need to know what you're.
I think our argument is principally going back to that sufficiency of the evidence, that there is not sufficient evidence that the jury should have been instructed with that instruction, and that there's not sufficient evidence to maintain that conviction. But in the alternative,
The evidence on the second,
because
because they found him guilty.
No, Your Honor, I would disagree. I would argue that because of the lack of forensic evidence, I mean, the point that the state made that he acknowledged that he shot his weapon, that's true. He did acknowledge that he shot his weapon. And had he been the only shooter, then a reasonable inference maybe could have been drawn that his weapon caused the fatal injuries. But because there was a second shooter, there's not a reasonable inference there, and the state failed to meet their burden to prove beyond a reasonable doubt that it was his weapon that killed the victims. So I would argue that because of the lack of forensic evidence in this case, because of the lack of ballistic evidence in this case, there's not sufficient evidence to support any of the convictions. But even if the court finds that there is sufficient evidence to support, based on the ballistics, that he killed these individuals, that the instruction that was given to the jury on felony murder was not, one, was not supported by the evidence and should not have been given, and two, was legally infirm because it was misleading, it was confusing to the jury, it did not provide the jury with an accurate statement of the law as to how they could find him guilty of felony murder.
What was, just following up on what you just said, what was legally incorrect about the felony murder instruction?
Because the instruction said, Your Honor, that in order to convict on the felony murder, they must find that the death of Leah Brown, the death of Tremel Dean occurred in the course of committing second-degree murder. That is not the only way that the jury could have found him guilty of felony murder. There were lesser includeds that were instructed in both of the second-degree murder charges that could have potentially also supported the felony murder conviction.
Let's just assume that you're right, that somehow that was at least an incomplete statement of the law. Isn't any incompleteness in what you just recited beneficial to your client as opposed to prejudicial? Because it narrows the potential grounds for a conviction.
I don't know that I would agree, Your Honor. I think alternatively, I think we could say that, and we have said, that it created the situation where the jury felt compelled to convict him of second-degree murder in order to convict him of the felony murder because there was such an emotional appeal from the state with regard to these other victims, Leah Brown and Tremel Dean.
So is your argument that the felony murder instruction, the confusing aspect of it, actually impacted the jury's deliberations on second-degree murder as opposed to it was confusing to the jury as it deliberated the felony murder charge?
Your Honor, our argument is it was confusing to the jury to the extent that it led them to believe that if they wanted to convict him of felony murder, they had to find that he had committed a second-degree murder. And I think you could necessarily read that that means they had to convict him of the second-degree murder. Now, I would acknowledge that that's not an accurate statement of the law in Kansas, but the jury wasn't instructed in that regard. And so when we tell them, in order to convict a felony murder, you must find that he committed second-degree murder, I think we're necessarily telling the jury that in order to convict a felony murder, you also have to convict him of second-degree murder. And that puts them in a situation of convicting him of a charge that hasn't been supported by the evidence.
Other questions? Thank you, counsel. Thank you to both counsel for your arguments this morning. The court will take this appeal under advisement.